filed. Have a good day. It's filed 25-7126-H. Council, you want to state your appearances, please?
Melissa Goodrich, Flint County Prosecutor.
And James Gilbert here on behalf of Mr. Berkey.
All right, we're here for sentencing and possession of methamphetamine, a 10-year maximum, 5 to 23 guidelines range. Any additions, corrections to that report?
No additions or corrections to the report.
Any scoring challenges from the defense?
No scoring challenges either. It came out exactly as predicted.
Ms. Goodrich, any additions, corrections, or scoring challenges?
No, Your Honor.
All right, Mr. Gilbert, anything you want to say in your client's behalf?
Yes, Your Honor. I would ask the court to follow the recommendation. I know my client's record is by no means close to being the greatest, and he acknowledges that also. But in working with Mr. Berkey, and I say this every once in a while, I still come across a client that is easy to work with, acknowledges what they did was wrong. That was Mr. Berkey. He went through what the changes he's made since he's gotten out of prison before, and things that were going, and I think he's going to explain it a little bit in his statement too. And most of it seems accurate. It doesn't seem like it's something he's just trying to tell you so that you give him a lower sentence. And I would point out, this was a true possession charge. And I believe there's a little bit of residue on a pipe, and then there was a small amount, less than a quarter gram in a little glass container. So it was very small, and it was definitely for personal use. There was nothing here that he was distributing amongst the community. And so I'd ask the court to take that in consideration. And again, I can't stress enough how easy it was to work with Mr. Berkey. And so I'd ask the court to follow the recommendation.
Okay, thank you, Mr. Gilbert. Mr. Berkey, you don't have to say anything today, but you're welcome to. Is there anything you want to tell me, sir?
Yeah, I can't prepare to state.
That's fine.
It's kind of new. I haven't really done this part before.
It's okay.
I've always just went ahead and took my punishment without.
Okay.
So I get a motion.
It's okay, take the time.
Your Honor, so I stand before you today making a very bad decision and for selfish reasons. So I accept full responsibility for my actions and the decisions that led to those actions. In August of 24, I was released from prison. It came out to nothing. I was on a homeless status for more than a week. That's where my journey started out very bleak. So I was able to get a painting job for cash, and it got me some work clothes, some boots, food, and the phone. And I had contacted my then ex-wife to set up a visitation plans to see my daughter, my son, and my stepkids. So, but after talking, we kind of worked things out, and I moved back home. So we were remarried in November of 2024, and this was kind of like the turning point for me. So since my release in August of 24, I worked very hard and made milestones of progress. So I completed over a year of tether, passed every drug test ever given, found gainful employment, obtained my driver's license after over 30 years of not having it, obtained a business license and started a business in Pellston, and acquired the needed insurance and comp insurance. So I enrolled in courses to obtain an associate's degree in business science from Colorado Tech and was due to graduate this year in September. And I have reconnected with my older children and made significant progress in rebuilding a relationship with them. And I can't say any of this was easy, but after a while, things got kind of rough, waiting for my business to take off and contracts to start. So we were facing homelessness and some shut-off notices, and I was struggling, trying to deal with the stress and anxiety and all the issues of that. And I kind of let foolish pride stand in the way of asking for help. I didn't want people to see me as a failure. Felt like letting them down. So for the first time, people were proud of me. People were actually on my side, and the thought of losing all that was my downfall. That irrational thought started a downward spiral, and I lost it. A few days before my arrest, I relapsed. I thought I could just get away from it all, and everything would, be okay. This was my biggest mistake. I chose to play hero, the tough guy who didn't want to lose, and that's ultimately why I'm here today. So, Your Honor, I want to finish what I started and successfully discharge my parole, build my business up and my life with my family, and finish the future that I had planned for them and with them. To be honest, I don't think going back to prison is the answer. I've done that before, and it's never helped. So I deserve to be punished for my actions. I agree. I am 100% confident that with the court ordered a county jail sanction that I can get out, finish my parole, and succeed in what I started. Your Honor, I beg the court to allow me the opportunity to prove that I can do it for my family, for my parole officer, this court, and above all, for me. I've never been this dedicated to succeeding. I don't want a mistake to be the end of it. I have to start all over again. I've done that too many times. I want to finish this, Your Honor. Please allow me that opportunity. I will not fail again. Thank you for the opportunity to plead my case.
Great, thank you, sir. Ms. Fiducci, any recommendations from the people?
Oh, yes, thank you, Your Honor. The defendant is 52 years old. He does have a significant criminal history with 10 prior felonies, 6 prior misdemeanors. He was 18 at the time of his first arrest. He's gone to jail 3 times. He's gone to prison 5 times, and he's been on probation 4 times. He was on parole at the time of this offense as well. At this time, with the guidelines being 5 to 23, I would recommend mid to high guideline range due to the significant criminal history and the fact that he was on parole for multiple cases at the time of this offense. Thank you.
All right, thank you. Well, Mr. Berkey, as you can tell, given your significant prior record, that it doesn't take a whole lot for you to be in jeopardy of going back. That this is a very small amount, clearly a personal use amount of drugs in a car on a traffic stop. And the guidelines would allow you to go back to prison, and it sure sounds like the prosecutor's asking me to do that today. I'm not going to do that today. I'm not going to return you to prison. And that's because of the progress that you have been making. And I'll tell you, Mr. Berkey, even though this is a small amount, I don't tend to want to sentence people to prison for true possession cases. On rare occasions when I have done it, it's been because they're people with exactly the criminal history that you have. So, and you've been in and out of prison the last 20 years. It sounds like, though, aside from, the relapse here, you were starting to gain some traction. So the hope is that you would continue to gain some traction, and, you're in your 50s now. I imagine you want to have some enjoyment of life, not on the inside. That's 100% your control, Mr. Berkey. You know the things that you do to get you standing in front of a judge. And so you know the things you have to do to avoid that from happening. So, I think on the balance, because of the progress that you made, and because of the small amount that was involved in this case, I am going to follow the recommendations of the Department of Corrections and your attorney and sentence you to a county jail sanction of 9 months. That is mandatory consecutive to the parole violation. And because there's a detainer, there's no credit you get for the time that you've served. It's 9 months from now. There's also a crime victims assessment of $130, court cost of $350, state cost of $68. I think given one of Mr. Berkey's prior convictions, I don't know that he's eligible for trustee programming in the jail or anything. You might be eligible for, well, I don't know if you're eligible for the CBT program anyway, because that's community corrections programming. I don't think you'd be eligible for that either. If you while you're back there think that you are eligible for some of those programs, just send out a kite for a motion form and ask me at that time. But I think you're probably ineligible for that. This is a sentence within the advisory guidelines, which is also within the terms of the plea agreement. I think it's proportional to the circumstances of the offender, particularly, and also to the offense, given his extensive prior record. So, Mr. Berkey, if you wanted to appeal, you could do so by filing an application to the Court of Appeals. If you wanted a lawyer appointed, you'd have to ask within 6 months. So I'm going to hand you a piece of paper right now. The bailiff is explaining those appeal rights. Ask you to initial 1 copy for us, so we have a record we gave it to you. The other one's for you to fill out if you wish to take an appeal. Do you have any questions for me, sir? Okay. Good luck.
Thank you.
Got that sticking on. It's going to need your initials. Grab some line right there. All right, this brings us to People v. Chad Powell, file 25-7125FH. We've got the prosecuting attorney, Ms. Goodrich, defense counsel, Mr. Gilbert, and Mr. Powell present in the courtroom. All right, I have we're here for a docket call, and I have a plea agreement and vice of rights in front of me, and that's how we're proceeding, counsel.
It is, Your Honor. Thank you.
Okay, Mr. Powell, as best you can, would you raise your right hand for me? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you can put your hand down. Are you Chad William Powell?
I am.
Mr. Powell, a guilty plea hearing is an important event. It includes the waiver of constitutional rights that you have, so listen carefully. If you have a question, ask me. If you need more time to talk to your attorney, you just say so at any time. Do you understand that?
I do.
I have to advise you the maximum penalty that you could face for the charge that you'd be pleading to. And that's count one, operating while intoxicated as a third offense. That's a felony punishable by a fine of $500 to $5,000 and either 1 to 5 years in prison or probation with 30 days to a year in jail, at least 48 hours to be served consecutively, and 60 to 180 days community service. The court can order rehabilitative programs, costs of prosecution and emergency response, and vehicle immobilization. Do you understand the maximum penalty?
I do.
Were you on probation or parole anywhere?
No, sir.
Were you on bond for any other case at the time of this incident?
No, Your Honor.
Did you read and understand the rights listed on the advice of rights form you signed?
I did.
Do you have any questions for me or Mr. Gilbert about any of those rights?
No, Your Honor.
Do you understand if you plead guilty, you give up those rights and won't have a trial?
I do.
And is that what you wish to do today?
Yes.
If I accept your plea, you also give up any claim that it was caused by threats or by promises not placed on the record today. Do you understand that?
I do, Your Honor.
Also, when you plead guilty, you lose the right to appeal. And if you want to appeal, you have to seek permission by filing an application. Do you understand that?
I do.
But the types of issues you could raise on appeal if you plead guilty are very limited, much more limited than if you were convicted after trial. Do you understand that?
I do.
The plea agreement provides that in exchange for your plea to count one, as I outlined, the prosecutor will dismiss count two and also will dismiss the habitual notice. There's $225 OWI reimbursement. And there's a sentence agreement that any incarceration ordered shall not exceed 180 days within the probation term set by the court. Do you understand the terms of that agreement?
I do, Your Honor.
Mr. Gilbert, is that a full, fair, and accurate statement of his terms?
It is, Your Honor.
Ms. Spears?
Yes.
Mr. Powell, I don't recognize you or think I know you or know really anything about this case. Your attorney and the prosecutor know a lot more than I do right now. So I don't know whether I would want to follow this sentence agreement or not. At the sentencing, I'll know more through what you and your attorney tell me, through what the prosecutor tells me, and through a pre-sentence report. So at sentencing, I may decide I can't go along with this, and I don't have to go along with this. But if I didn't follow a sentence agreement, you'd be allowed to withdraw your plea, not receiving what you bargained for. Do you understand that?
I do.
That's unless you engage in some misconduct between now and then, either violation of court order, or absconding, or trying to escape, or committing a new offense, anything of that nature. You would lose the right to withdraw your plea, even if I wanted to give you more than 180 days. Do you understand that?
I do.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, sir.
Has anybody threatened you to make you do so?
No,
Is it your own free choice to enter that plea?
it is.
Knowing all this, how do you wish to plead to the charge of operating an intoxicated third offense?
Guilty.
So, Mr. Powell, back on October 29th of 2025, were you in Sheboygan County?
I was.
Did you, were you operating a motor vehicle on West US 23, a public highway?
Yes, Your Honor.
Before you had operated that vehicle, had you consumed alcoholic beverages?
Yes.
Did you have some contact with law enforcement?
Yes,
And did they give you a test to determine the amount of alcohol in your body?
they did.
Do you recall what the results of that test were?
I believe it was 1, 2, 3.
Okay, so that's above the legal limit of 0.08.
Yes, sir.
And at the time, did you have a previous conviction for operating while intoxicated from 2022 in the 91st District Court?
I did.
And also in 2023 in the 91st District Court?
I did.
Okay, Mr. Gilbert, you satified with that factual basis?
I am. Thank you.
Ms. Goodrich?
Yes.
Mr. Gilbert, you aware of any other promises, instruction, inducements?
I am not.
You believe I've complied with the court rule?
I believe you have. Thank you.
Ms. Goodrich, do you agree?
Yes.
Mr. Powell, I find that your plea is knowingly, understandingly, and voluntarily made, and that there's a sufficient basis in fact and law to believe that you're guilty of that offense. So I hereby accept your plea. We could schedule sentencing for April 28th at 2 p.m. And you'll have to cooperate with a pre-sentence report where the probation department will interview you so they can write a report for me. So I know more about your facts and circumstances so we can determine what's an appropriate sentence. Do you have any questions for me about that? Okay, Mr. Gilbert, anything further from the defense?
No, Your Honor, thank you.
Anything further from the people?
No, Your Honor, thank you.
Okay, we'll see you then, sir.
Thank you. Okay. Yeah.
Okay, Mr. Gilbert, I have Mr. Jalen McGee on Zoom. He did appear here in person this morning and